claim in the matter of Gormandy and two others against Trinidad and Tobago Housing Development Corporation.
Good morning, Mr. Andy Gardner.
Good morning.
I wonder if I could ask you to begin by addressing us on the question which you have focused in your case and which has also been raised by the respondent about whether or not the rule in Devi and Roy would have the effect of excluding this appeal.
My Lord, yes, the position on that issue, which was fairly, of course, raised by. I should do the introductions first. I'm sorry, my Lord. That I appear, obviously, for the appellants with Mr. Ramesh Lawrence Maharaj in the jurisdiction, appearing with us remotely, and my learned junior Ms. Dodds. And for the respondents, we have Deborah Peake, senior counsel, on your screen, who's leading Ms. Ravi Hafez-Doon. My Lord, yes, on the Devi and Roy point, what is said against me is that there are two concurrent findings of sets of concurrent findings of fact, if one likes, made by the court at first instance and the Court of Appeal. The first sort of finding of fact that is said to have been made is that Mr. Gormandy was found by both Mr. Justice Rahim and the Court of Appeal to have exaggerated the extent of his land holding. Both Mr. Justice Rahim and the Court of Appeal say that when he said he occupied 4.6 acres, that wasn't correct. That's the first finding of fact. And the second is a sort of group of findings that I identify under the second question, which is, in essence, a question about the uncertainty of the boundaries, but also then evidence that there was concurrent use for part of the time of some of the land by the occupiers for the time being of the Julian-Carillion compound, which lies to the west of the subject properties. And secondly, that there was evidence from Mr. Dubai, one of Mr. Gormandy's witnesses, that the members of the public were dumping rubbish at the bottom of what was identified as Keskidi Avenue, which is an avenue running north-south, approximately down the middle of G1. On the first point, as to the finding that Mr. Gormandy presented to the court an exaggerated claim, the appellants essentially pray and aid the exception to the principle. Well, they say two things. First of all, the process by which Mr. Justice Rahim determined that issue did not involve a finding of fact. He was applying judicial notice of what he considered to be an inherent characteristic in a Trinidadian farmer who would be inherently very good at estimating land sizes. The application of judicial notice is of itself presupposing the absence of evidence which needs to be bridged by the application of that judicial notice. The Court of Appeal, in my submission rightly, then said that Mr. Justice Rahim ought not to have deployed the concept or the label of judicial notice to the exercise he was undertaking, but that instead his judgment could be understood as the exercise of judicial common sense. So the first point I'd wish to make is that properly analysed, in my respectful submission, the first finding by Mr. Justice Rahim is not properly so-called a finding of fact, but a deployment of an inappropriate device to bridge a gap in the facts. But secondly, both of the approaches of both of the courts fall within an exception from the rule of Devi and Roy, which is essentially that exception which recognises that the principle or the practice does not apply where there has been some procedural error or wrongdoing. And the procedural error or wrongdoing on which the appellant further relies is that on an analysis of the cross-examination and the pleadings, the suggestion was never made to Mr. Gormandy that he was coming to either court with an exaggerated claim. That is close to, if not an actual allegation of wrongdoing against Mr. Gormandy, and that should have been fairly and squarely put to him in cross-examination. And in my case, I cite two authorities that indicate that if a witness is to be disbelieved on that sort of thing, they ought to be have that point put to them directly. So I say on the first issue, the boundaries acreage issue, as I've called the first issue, that the principle doesn't apply because of the nature of the finding of Mr. Justice Rahim. But if it does apply, both of the courts deployed, or both of the courts came to a decision which they were not entitled, in fairness, to make against Mr. Gormandy, because both of the courts recognised expressly in their judgment that it entailed a finding that Mr. Gormandy was coming to them with an exaggerated claim. That was both against the weight of the evidence that he gave in my respectful submission, but it was also not an allegation that, or not a finding that ought to have been made without Mr. Gormandy being asked about it. So that's issue one. On issue two, there are, it is right, findings made by the learned judge, Mr. Justice Rahim, which are then repeated in the judgment of the Court of Appeal, and to that extent are concurrent findings of fact. However, the material facts that were referred to in my respectful submission also are not captured by the practice in Devi and Roy. This is for two reasons. Taking the concurrent use points first, the two pieces of evidence that were relied upon in the main by Mr. Justice Rahim as showing that Mr. Gormandy occupied less than his 4.6 acres followed his wrong in my submission determination that he could find that Mr. Gormandy had exaggerated his claims. So these findings follow on in Mr. Justice Rahim's judgment from that earlier finding. He then identifies two factual matters which he says substantiate that first wrong step. The first factual matter is that he says there is in existence a fire break along the western boundary to the Carillion-Julin compound, and that was taken as being evidence that Mr. Gormandy was not in exclusive possession of that part. And secondly, as I say, he attached weight to the dumping of rubbish at the top of, or rather the bottom of Keskedy Avenue, as showing that there was no exclusive possession in that area either. The difficulty with those submissions is first that they, with those findings, is first that they follow the first and wrongful step taken by Mr. Justice Rahim under the rubric of judicial notice, and then remedied in form but not substance only by the Court of Appeal as being an exercise of common sense. But secondly, the material on which he relies as being evidence of concurrent use was not examined from the point of view of the established principles of adverse possession, and whether or not concurrent use by a third party would mean that the putative squatter was not himself in exclusive possession. And the authority which we rely on in relation to that is the Fowley Marine case, which is in your Lordship's bundles at 2311. And the passages on which we place particular reliance are the passages at 2330 and 2331 in the report. This was a case in which there had been evidence that members of the public had, in relation to land which was being possessed, exercised certain mooring rights in relation to that land. And the question was whether that concurrent usage by those members of the public meant that the putative possessor was not in possession. And the relevant passages I'd like to focus your Lordship's attention on are at 2330 between D and E. In those passages, Lord Justice Wilmer says, one difficulty in relation to this being the moorings, apart from the 6 moorings laid down on the instructions of Mr. Woodley, we do not know whether any significant number of persons have laid permanent moorings in the Rythe without permission. Now, if any significant number did so, nor if any significant number did so, do we know with what animus they did so. The inference which I would be inclined to draw is that any person who did lay such moorings without permission probably did so in the erroneous belief, as argued on behalf of the defendant, that they were entitled to do so as an ordinary incident of navigation. The next passage is significant. There is no evidence to show that anybody, not even Mr Woodley, ever laid any such moorings with any animus possidendi, whether of the Rythe as a whole or the particular spot where the moorings were laid. And he then refers to a dicta of Lord Watson in Lord Advocate and Young, where Lord Watson says at letter B, the proprietor cannot exclude the public from it in any time, and it is practically impossible to prevent occasional encroachments on his right, because the cost of preventative measures would be altogether disproportionate to the value of the subject. So those dicta, I say, mean that one can not simply point to use of land concurrently by a third party, and say that that means that the putative adverse possessor is not in possession of that land. It requires the evidence to be led that shows how often, how frequently, to what extent, and with what animus use was being made. Now, in this particular case, in relation to the Julin fire break, we don't know at all when and how frequently the Julin fire break was installed. We had evidence from the photogrammatic expert, or the surveyor expert, Ms. Mohammed, that the Julin fire break was not always there, and that there was cultivation to the boundary of the Julin fence. We have evidence from the respondent's witness, Mr. Hackshaw, who was cross-examined, that he did not himself see the fire break. So the evidence was not there that would have allowed either Mr. Justice Rahim or the Court of Appeal to find that the installation of the fire break was an act which prevented Mr. Gormandy from being in possession. And in my respectful submission, the same is also true of the dumping of rubbish. The dumping of rubbish evidence appears only in one place in the evidence. It appears in the evidence in the cross-examination of Mr. Dubai, and all he says is that members of the public were accustomed to dumping their rubbish for a period which he does not specify in a location around Keskady Avenue, which may or may not be partially, wholly, or not at all on the subject matter land. So the concurrent use points we deal with by saying that they are impeached by the fact that there is a failure to apply the law properly as it applies to concurrent use by third parties. Not any use by a third party will do. The use has to amount to something, as identified by Lord Justice Wilmer in Fowley Marine, as itself amounting to a significant, substantial act of possession from which one can say that Mr. Gormandy was not in possession. A, the acts don't amount to that, and B, we have evidence from Ms. Mohammed and her analysis of the photographs that there were times in which the cultivation went to the Julin fence. Apart from the concurrent use evidence, there were a few other points that were relied upon by both Mr. Justice Rahim and the Court of Appeal falling under the second head.
Can I just be clear? Yes. So in relation to the point you've just been making, you're saying that the lower courts have made an error of law?
Yes, it didn't apply the correct legal test. It isn't enough. The law of adverse possession does not require the squatter to hermetically seal the land he or she or it is claiming. The animus possidendi that must be shown is an intention to exclude the world, including the true owner, so far as reasonably practical in the process of law will allow. The law of adverse possession itself contemplates that a squatter does not need to be in a state of perpetual warfare with the world at large. They just need to demonstrate activity of a sufficient permanence, taking into account the character of the land, that would lead one to conclude that they are in possession of it.
But you may correct me if I've misrecalled this, but my reading thus far suggests that the trial judge accepted that there was animus possidendi.
Yes.
It wasn't really an animus possidendi problem. Your client has succeeded on that.
Yes.
It was much more to do with over what.
Absolutely. That's.
So I don't quite see how a supposed Fowley Marine and Gafford mistake gets into it. If you succeed on animus possidendi, how can it be that you've suffered in some way from a failure to apply that principle with sufficient thoroughness? It's not to do with the animus possidendi of the people who are dumping the rubbish or the people who are laying the fabric, is it?
No, my lord. What I'm relying on the Fowley Marine principle for, and also it might be useful just to go to the Bly and Martin authority, which makes the same point at 2340. I'm sorry, I'm just catching up with.
Lost our link.
If you could pause a second,
yes, of course.
We seem to have lost touch with the Respondent's counsel. We'll see if they come back.
She's on this screen, my lord. She's still on the right-hand screen.
We've lost her on this screen.
Here she is.
She's back, thank you.
So my lord, I agree with you that the Court of Appeal say in express terms in this case that Mr Gormandy succeeded on demonstrating the animus possidendi. What the Fowley Marine Authority and what is said in Bly is intended to go to is that when assessing whether or not a squatter is in possession, when the physical control is to be measured, the law accepts that to a degree there may be concurrent third-party use with that squatter, which does not negate his possession of the whole. And the court in Fowley Marine sets out the test for assessing when concurrent third-party use is sufficient to defeat a squatter's claim for exclusive possession. And the passages I've referred you to from Lord Justice Wilmer make clear that it must be understood with what intention and how frequently the interloping third party made concurrent use of the land before one can conclude that that interloper has negated the putative squatter's adverse possession. So your lordship is right, and I've probably expressed it badly the first time round, that it isn't. I'm not quarrelling about animus possidendi, but I do say that in this case, an aspect of adverse possession which is not overburdened with authority, which is the question of to what extent concurrent use by a third party negates exclusive possession, that in this case the courts misapplied or didn't apply the law in that regard, as set out in Fowley Marine.
And you're going to refer us to Bly at 2340.
Yes, apologies. I was just scrabbling for the passage that we wanted to refer you to. Could I just take a moment to try and locate it? I'm sorry.
Please do.
Shall I give you another link? No, that's fine. Thank you. Thank you. Yes, no, it's really just, I think, the point at the bottom of 2.3. So my learned junior is riding to my rescue. Thank you. So it's really the passage at the bottom of 2340 where it says, 1, possession is a matter of fact depending on all the particular circumstances of the case. In many cases, possession cannot, in the nature of things, be continuous from day to day, and it is well established that possession may continue to subsist, notwithstanding that there are intervals, sometimes long intervals, between acts of user, and it refers to Lee and Jack. He then goes on to refer to the case of arable farmland. And then underneath the quotation from Allen and England, so just above letter E on page 2341, Mr Justice Pennyquick says, Mr Francis relied upon that case as an authority for saying that whenever the lawful owner puts foot on land in the possession of another, then is to be treated as having taken possession himself, so that the adverse possession ceases. So this is the true owner rather than an interloper. I do not think that case is an authority for such a proposition. Allen and England is a case of permissive user of garden where the owner paid periodic visits to the garden. In those circumstances, the way in which Earl C.J. put it was no doubt correct, but the way he puts it is not. In essence, these are just parts of the authorities which are intended to demonstrate that the correct approach the court should take to the third-party non-owning interloper is that the court needs to make a proper assessment of the nature and extent of that interloping and the intention with which it is done. That was not done here. So the evidence that we have in relation to the dumping is of irregular, unquantified use with no evidence at all of the intentions with which it was done. And in relation to the Julian fire break, we have evidence that it was not always there, was not always visible, including to one of the respondent's witnesses who attended site. And again, no evidence at all, quo animo, that fire break was there. So in those circumstances where we have evidence of ploughing and preparing the ground, and on the basis of the evidence of Ms. Mohammed, photogrammatic documentary evidence that suggests cultivation periodically up to the Julin fence, in my respectful submission, the courts below erred in not having proper regard to the principles in Fowley Marine, where they're most clearly set out. There are very limited authorities on this question in assessing what had happened on the land. So I say that's the legal error. It's not the factual finding I'm disputing, it is its legal implication. And I say the legal implication drawn is wrong because the court did not look at Fowley Marine.
Was the court asked to look at Fowley Marine?
The court was provided. The Court of Appeal certainly was provided with Fowley Marine in the submissions, and I think it was also referred to below. I'd need to check that.
I suppose it's difficult to do an adverse possession case without, at some stage, referring to Fowley Marine.
Yeah. Yes. But as I say, I've in the course of preparing this appeal, there are surprisingly limited authorities that speak to the legal test, and Fowley Marine seems to be the only authority that really deals with it in any detail. So that is what I say the error of law is, that infects both of those findings of fact. Those were not the only matters of fact that Mr. Justice Rahim, having found against my client on the basis of an inflated claim, those are not the only facts Mr. Justice Rahim and the Court of Appeal referred to. In addition to that, both of the courts referred to a letter from the Ministry of Agriculture, which is at, I think it's at page 407. No, that's a picture of a plant. I'll just need to find that. Sorry, my reference has gone awry for that. But there's a letter from the Ministry of Agriculture which is referred to, which is at page 621. Thank you. Which the courts also said was consistent with Mr. Gormandy claiming less. It's a letter from 2013, so after the limitation period that we're referring to. It is addressed to whoever it may concern, and it certifies that Mr. Gormandy is a bona fide farmer and is registered under the Farmers Registration Programme. And the passage, or the part of that letter that is referred to by both courts, is the acreage, and it's very faint, but it is 2.5 acres is what is said there. Now, or at least that's what it said.
The major farm activities are said to be?
I think what that says is, at the end is tree crops, and I think what it was said, it was ahead of that was vegetables, yeah. Now, in addition to that, of course, we know that Mr. Gormandy had other things going on the land. In particular, around that time, he had goats and sheep, but that isn't referred to in the major farm activities. And nor was Mr. Gormandy referred to this letter in the course of cross-examination, and was therefore not in a position to proffer an explanation to it on the basis of the challenge.
I thought he introduced the letter himself.
He did introduce the letter himself, that's true, but it's important to bear in mind that in the course of cross-examination of Mr. Gormandy, at no point did the significance of a discrepancy in acreage become an issue. He wasn't asked about, at any point, about why there was a difference between 3 acres and 1.86 hectares or 4.6 acres. The cross-examination of Mr. Gormandy at all times proceeded, with one or two exceptions, but at all times with those exceptions proceeded on the basis that what he was claiming was the 3 acres. There was no issue put to him that he was claiming anything else than that.
But he must have known, once Miss Mohammed produced the plan, he must have known that there was a significant difference between what he'd been talking about and what the plan showed. And my understanding is that Miss Mohammed pointed this out to him.
Yes, the difficulty one of the many difficulties in understanding what's happened in this case is that that point doesn't seem to have fed into the trial process to any degree. When Mr Gormandy is cross-examined in relation to that, and I can take your lordship to it, it's essentially starting at 871 in your bundle. In the course of his cross-examination, he is shown the cadastral plan, and he is asked about it at 872. He's asked whether it's familiar. Yes. He's asked whether it represents the land. He says it represents the land I was occupying that I sold. What represents the land you were occupying? Pointed out. It looks like G1 and G2. The land that I retain is G2. Now, G1 and G2 are only features of the cadastral plan, so that must be the document that he's being referred to. And that is one thing he's being cross-examined upon. And he confirms that that is...
The onus of proof always remains on him to establish the area of land which he was occupying. And he says at one stage he was occupying 2.5 acres. And at another stage he says he's occupying 3 acres. And another stage he's claimed to occupy 4.6 acres. That is to be seen in the context that he doesn't know where G2 is. He moves it around.
Yes.
So hardly a reliable witness, and giving conflicting accounts of the area of lands he occupied.
Well, my lord, first of all, the point that's made in relation to Mr Gormandy is obviously that he has not the formal qualifications to undertake the measuring.
But that was an issue that was before the court. They were able to assess Mr Gormandy.
Yeah, yes, but the second point is that if one then accepts that he's not very good at assessing land areas and ditches his evidence in relation to that...
Did he say that?
Well, my lord, one can see from the evidence that everyone still proceeded, even with the Mohammed cadastral plan in hand, everyone still proceeded to cross-examine on the basis that this land was the 3 acres. And in fact, the land is called by shorthand the 3 acres all the way through the proceedings. But what we know is that Mr Gormandy helped Ms Mohammed by pointing out where the boundaries were, which she then reduced to the cadastral plan. We know that he gave evidence that in 1984-5, when he came to the land, he marked out the boundaries of that land, which he wished to cultivate. We know that he planted trees on the northern and eastern boundaries and guava in the middle of that land, which was corroborated by his common law wife's evidence, Bianca Banswell. And his evidence was that he had prepared the ground, having marked out the boundaries, and got it ready for crop rotation. And at all material times, when he was asked about whether the land he had marked out was the land he was pointing to in the cadastral plan, he said, yes, it was. That was, to a degree, corroborated by the independent documentary evidence of Ms Mohammed, whose evidence was that, which was, quotes, not destroyed in evidence, according to Mr Justice Rahim, that there was planting throughout G1 and G2. That is her description of the photographs from 1989 onwards. And secondly, she accepts, of course, that it wasn't all taken in hand in one snapshot, but nonetheless, the activity that she identifies appears to be consistent with what Mr Gormandy is saying, that the planting was throughout G1 and G2. So, my lord, I accept that on the one hand, one has these different acreages, but on the other hand, we don't have at any point the explicit suggestion being made to Mr Gormandy that he has exaggerated his claim, or that the explanation is anything other than he's just not very good at measuring or assessing land masses. What we do know is that he attends the site with Ms Mohammed in 2017, points to the ground and says, this is the extent of my occupation.
But at that stage, it's a desert. It's been completely obliterated. What on earth was he referring to?
Well, my lord, what his evidence was, that is what he was referring to, his extent of occupation on the ground, and he was not asked, it was not suggested to him that he was giving Ms Mohammed a false account of his occupancy.
I mean, what Miss Mohammed will have seen on the northern and the top part of the eastern boundary would be Mr Sammy's wall.
Yes.
By then.
Yes.
And the photographs are reported at page 500, is there something like that?
I'll take it.
Or no, just before that.
So the photographs post works are to be found at 356.
Well, 483,
And
482, and so on. 479. I mean, it's just a building site.
Well, yes, my lord, but the evidence that he gave was that when he attended site with Ms Mohammed, he having been there since 1984-5, was that he pointed out where his occupancy had been, which Ms Mohammed transcribed. And what is missing from the record is any suggestion that he had somehow falsified or inflated what he had pointed out to Ms Mohammed at that point in time.
Can I just take you back to, as I understand it, your primary submission in relation to your issue 1? As I understand it, you are submitting that this case does not fall within the Devi and Roy practice because, well, it's not entirely clear to me what you're saying, but one of the arguments is because the courts applied either judicial notice stroke judicial common sense, and that might be regarded as therefore not quite a finding of fact. Allied to that is, as I understand it, the submission that Mr Gormandy should have been cross-examined about the discrepancy in relation to his understanding of the acreage.
Yes.
Now, if we just take those, I mean, it's not clear to me why you say that judicial common sense, as it's ultimately been described, would take you outside Devi and Roy. I mean, why wouldn't one say that the judges on the ground, looking at the facts, are perfectly entitled, and it's not really for us to go behind, their application of their common sense? Why is that a problem under our Devi and Roy approach?
So if I could approach that at the two levels my Lord Burroughs has articulated. The Devi and Roy principle, as we know, applies to concurrent findings of fact, which this court does not go behind unless one falls within exceptions. One then has to identify what the finding of fact is that is made for the principle to apply. Mr. Justice Rahim did not make a finding of fact in the narrow sense, I would respectfully submit, because what he did was to apply wrongly judicial notice, which he had to apply to get to the outcome, because he did not, precisely for the reason that he did not have the facts before him to get to the conclusion he did. So I say that was an improper application of judicial notice, and it also presupposed not a presence of evidence on which a finding of fact was made, but an absence of evidence on which no finding of fact could be made, which had to be bridged by judicial notice.
But I mean, it's commonly the function of a trial judge to bridge evidential gaps by the use of a practical toolkit which consists of a mixture of inferences, common sense, sometimes judicial notice. But it doesn't mean, does it, that having done that bridging exercise and made findings, those aren't findings of fact. He has to make findings sometimes of fact to bridge gaps in evidence, because a finding of fact and an absence of evidence aren't necessarily inconsistent with each other.
I understand that, my lord. That if your lordship isn't with me on the first point, though, on the second point, it still then raises the question as to whether that was a permissible finding for both courts to make.
Oh, yeah.
In circumstances in which it wasn't exposed to the party in question for comment. And I'd just like to perhaps if I could just get back into the groove of that first issue, take your lordships to why I say this wasn't simply an innocuous exercise of a judicial fact-finding function to use common sense to understand a factual picture, but it went rather further than that.
Well, what fact is it that you are, in a sense, if you're not pushing the fact that it's not a factual finding, what is the factual basis that you're, in a sense, objecting to, that you say there's no evidence for?
It's the finding which I'll have to make good by taking you to passages in the judgment of Mr Justice Rahim in the Court of Appeal, in which both courts articulate that there are only really two explanations for what Mr Gormandy is doing by claiming 4.6 acres. Either he's just made an error about the acreage, or he has come to the court with a deliberately inflated claim.
Might all this be said to be feeding into a single finding of fact, which we see in paragraph 408 of the judge, which is that Mr Gormandy only cultivated part of the subject land? I mean, is that not the finding of fact, that he only cultivated part of the 4 point whatever acres?
The difficulty, and this is part of my argument on this appeal, is that the way that Mr Justice Rahim gets there is by making the decision that Mr Gormandy has inflated his claim. That is the first step, because in his judgment he says, having made that finding having been the finding that there was an inflated claim, he then turns to the bits of evidence I've discussed earlier.
But he lists in paragraph 408 a range of factors which have led him to the conclusion, seemingly of fact, that Mr Gormandy only cultivated part of the land.
Yes, but in terms of the structure of the judgment, what you'll see is that he only goes to those facts having decided that Mr Gormandy has inflated his claim. That is then the lens through which the issues in 408 are examined. But what he doesn't then do as a result of that is to make a proper assessment of the concurrent user evidence in relation to the foul and marine principles, and nor does he take into account that, for example, the ministerial letter was never exposed to Mr Gormandy for comment. So I think, my Lord, what I'm trying to say is that the shift to 408 follows a decision that is made, because he makes that decision, he says, having made that decision, that Mr Gormandy has inflated his claim, and that is the lens through which then the other factual material is looked at in 408. And in my respectful submission, that isn't something that he ought to have done. And maybe to show you why I think why I submit that is not an innocuous exercise of the judicial function, I should just take you to how it is that this features. So Mr Justice Rahim's, the sort of fulcrum of his judgment, where everything turns against Mr Gormandy, is paragraph 401. He has listed...
You have a page for that?
I'm so sorry, yes, 1400.
Thank you.
It's one of those depressing judgments that one reads when one is an advocate, where everything seems to be going well until it doesn't. Up until paragraph 399, Mr Justice Rahim is saying Mr Gormandy is a bona fide farmer, and there's no doubt he had an occupation on the site, and all of the other things that are there set out, that he is in continuous occupation of the site, that his farming activities are extensive. At 400, the sun disappears behind a dark cloud. The extent of the land occupied is, however, an issue, and he then discusses the acreage issue, and he discusses the boundary issue. He then at 401 says, when the chaff is dusted off, the only evidence of extent of occupation left in this case comes from Gormandy and no one else. And as I took your lordships to earlier, Mr Gormandy, when he had the cadastral plan put to him, said, that's the land I'm occupying, that's the land I was sold. Gormandy's case is that he believed that he occupied 3 acres and only realised that he occupied more after the survey. The court must therefore ask itself whether it is reasonable to believe that in all of the circumstances of this case, Gormandy could have made such an error, or is it that he wants the court to believe that his occupation was actually more than it actually was in an effort to claim the entire parcel. So that section of the judgment turns this into an assessment, not just of the user of Mr Gormandy, but also disbelieves Mr Gormandy's evidence that he occupied the whole parcel by coming to the conclusion, as Mr Justice Rahim did, that what Mr Gormandy wants the court to believe is that his occupation was actually more than it factually was in an effort to claim the entire parcel. That is an attack on Mr Gormandy's credibility and honesty as a witness, and it allows the judge to get rid of the most cogent evidence that he has of the extent of Mr Gormandy's occupation, which came from Mr Gormandy himself. So Mr Gormandy is therefore disbelieved, and his claim does not reduce down to 3 acres, it disappears altogether. Exactly the same approach is taken by the Court of Appeal.
Before we go there, but there must have been to some extent a challenge to Mr Gormandy's credibility, because there was evidence that's recorded in the judgment of Mr Justice Rahim about his representations as to his income
Yes.
in relation to the rental of domestic property.
Yes.
So there must have been a challenge to his credibility.
There was a challenge to his general credibility,
Yes.
On the basis of applications he had made for rebates on rents for occupational purposes. And he gave an explanation in the transcript that in relation to that. What there was not a challenge to directly, I submit, was to Mr Gormandy's evidence that he said he occupied all of that land which was identified by himself to Ms Mohammed. And that's a very critical finding in this case, because it is that step that is taken by Mr Justice Rahim and that is taken again by the Court of Appeal in paragraph 98 of their judgment, that means that Mr Gormandy's evidence that he occupied the whole of the land, meaning 4.6 acres, just simply falls. And we've referred in the appellant's case to the basic principles, as we would refer to them, that need to be applied when disbelieving a witness on an issue, particularly one that's critical, which is that the matter should be put to him squarely, and that's the Village K Marina case at 2390 between A and C, and the Earl of Cardigan case.
It obviously was put to him that he had not occupied either the 3 acres or the 4.6 acres.
It was put to him at the end of the cross-examination. Those two were put to him at the end of the cross-examination. You are not in occupation of the 3 acres. You are not in occupation of the 4.6 acres. But the nature of the challenge was simply that he had not been in occupation of anything at all. There was not a suggestion that he had been in possession. There was not a suggestion to him that he had been in occupation of the 3 acres as a bona fide farmer, and had then deliberately inflated his claim to 4.6, which is a slightly different criticism of his conduct.
But if you're saying you have given evidence that you occupied either 3 acres or 4.6 acres, and I'm suggesting to you that you haven't, is that different from what you're saying should have been done? He was being challenged on his evidence that he had occupied any of this land.
My Lord, I would suggest it is different, and the reason why I would suggest it's different is that we have the sunny uplands of the findings of fact of Mr Justice Rahim that take us all the way to 399, in which he says Mr Gormandy is a bona fide farmer, etc., 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 and that he is good at averaging and must therefore be good at measuring land, and has therefore presumably is to be taken at his word that he did possess 3 acres. But that then and also, I should say, a finding which is contrary to the pleaded case and the evidence that was put forward by the witnesses for the respondent, that he was either not there at all or that his presence was so evanescent that it couldn't be measured as possession. The reason why it's not the same is that the case as it was decided didn't simply decide, well, you weren't there at all. It decided you were there, you're a bona fide farmer, but the reason you fail is because in the entirety is because we think you've misled the court. And that deprived Mr Gormandy of the ability to challenge that. And the reason why that is more than just a technicality is that when we get to the closing submissions made at trial at 1156 and 1157 in the judgment, in the bundle, we get the submission that the verbal description of the boundaries has changed, the paragraphs 1 and 2. We also have then the submission that the size of the lands has altered, and then we get the submission at 6 that no satisfactory evidence has been proffered by any of the witnesses for the claimants for these major discrepancies which go to the very heart of the claimant's case, and which quite surprisingly did not come to their attention before cross-examination. But that is where, in my respectful submission, the mischief in this case creeps in, because there is no explanation, because Mr Gormandy was never asked about that in that way. I accept entirely the point made by your lordship that there was a general challenge to occupation, and at the end of the cross-examination there was a general challenge that he was not in possession at all. But that is not the same as saying, as Mr Justice Rahim appears to have found, you are in occupation of something, you're good at assessing land masses, you assessed this at 3 acres, and you've come to this court saying it's 4.6. So that's where I say the mischief creeps in, and that's where I say that the fourth exception to the practice of the board in Devi and Roy is, in my respectful submission, engaged, because Mr Gormandy's case is disposed of on a basis that he has had no opportunity to deal with. So that's why I say that if the board is against me on the suggestion that the judicial notice exercise at stage 1 should nonetheless be treated as a finding of fact, the nature of that exercise was such that it deprived Mr Gormandy of the ability to explain the discrepancy, and deprived him of the opportunity of explaining whether it was a mistake, and it deprived him of the opportunity of rebutting the suggestion that which both Mr Justice Rahim and the Court of Appeal suggest he was doing, which is that he was pulling the wool over the court's eyes. So in my respectful submission, therefore, that was not a finding that was open to the trial judge or to the Court of Appeal for that separate reason. Just so that I am absolutely clear with the board, the closest that we get to a challenge on that basis is in the cross-examination at 880, which is the passage between paragraphs 7 and 11. Well, for sense, between 5 and 11, where he's asked about the land and that it hadn't been surveyed, and then the question, but you knew that it was a little more than 3 acres or a little more than 4 acres because of where you were occupying, correct? Yes, ma'am. So that's the question that he was asked, and that's the answer that he gave, and the question embraces both the 3 and the 4 acres and contemplates the land might be more. No suggestion is made to Mr Gormandy there that what he is doing is exaggerating, and you've seen the earlier passage in which he identifies the cadastral plan as what he said he was occupying.
Just remind me, he had a full-time employment.
Yes.
He also ran some private bar or activity from his own flat.
Yes, what I understand.
As well as running a market garden on 4.6 acres or 2.5 acres or 3 acres.
Yeah, he said, yes, he said that he initially worked as a hospital porter, then he worked for a company called Rotoplastics, and then he opened up what they called a parlour, which seems to have been an unlicensed, some sort of unlicensed cafe.
And was that at the same time as holding down his permanent job?
I think they were sequential. I think they were sequential. And the parlour he ran with his common law wife, Bianca, but
Was that at the time when he was incapacitated by having been shot in the leg?
I'd have to check. He was shot in 2006, I think, so I'd have to just check that, my lord. I don't have that detail.
Can I just be absolutely clear about the point? Is your point dependent on the view that you take that the court regarded him as being dishonest? Or is it a point separate from any dishonesty that he should have been challenged on the precise acreage question, irrespective of dishonesty? So what I'm saying to you, it seems pretty clear that what the courts below decided was that he was absolutely right. It was actually probably only about 3 acres. It's highly unlikely farmers are going to understand the extent, to this extent, of the land that they actually farm. So they took the view, as I understand it, that actually it probably was a smaller area than the full 4.5. Now, it's not clear to me that they were necessarily going on to rule him out by, oh, he's a very dishonest person, as opposed to, well, there may just be some underlying mistake or something of that kind in the way it's been presented. But are you saying that in any event he should have been challenged on that discrepancy? So leaving aside an issue about dishonesty,
Yes.
are you saying he should have been challenged in any event?
I think the short answer is yes, on the basis that if what is being said is you, Mr Gormandy, are coming here using the words 3 acres, I am cross-examining you on the basis of a plan that shows 4.6 acres and describing it as 3 acres in the course of my cross-examination, it is unfair, I would submit, to then be able to make the submission that there was a discrepancy if, as you've seen from the tenor of the questions, and the cross-examination is peppered with such references, if the tenor of the questions is that the document by reference to which Mr Gormandy is being cross-examined is that he is claiming 3 acres. That's the first point. The second point, my lord, is though that one cannot get away from the fact that both Mr Justice Rahim and the Court of Appeal, and I think it's at paragraph 98 in the Court of Appeal judgment, resolve the issue on the basis that Mr Gormandy has come to court deliberately inflating his claim. So the Court of Appeal say at page 1994, paragraph 98, that the trial judge was faced with the evidence of Gormandy's belief that he was on an occupation of 3 acres and a subsequent survey of the 4.6 acre parcel. Rather than accept one inference that Gormandy was simply mistaken about the true extent of his land, the trial judge accepted another inference that the discrepancy demonstrates a deliberate attempt to inflate the claim by Gormandy. The appellants argue that the trial judge only arrived at such a conclusion by improperly deploying the doctrine of judicial notice and so on. So first of all, my lord, if the cross-examination was, if the evidence was I'm in possession of 3 acres and it turns out to be 4.6 on a plan, then there should have been some cross-examination on the basis of whether or not the whole 4.6 parcel as opposed to the 3 acres was being occupied. There should at least have been some clarity in the questioning that didn't focus on 3 acres, treating it as being the mass of the disputed land. But the more serious procedural wrong turn that's taken is that both courts accept that Mr Gormandy has, in the words of the Court of Appeal, deliberately attempted to inflate his claim. And it is that facet of the judgment that means they disbelieve him in his entirety And that means that the court then says, oh, and incidentally, you lose your 3 acres as well because you haven't defined the boundary of that.
Well, they didn't disbelieve him in his entirety. As you say, things were sailing along nicely up to paragraph 198.
Yes.
Because you got the findings that he was a bona fide farmer who was farming part at least of that land.
Yes.
And that he had the requisite animus possidendi.
And he had the requisite animus possidendi, absolutely. But he then fails in its entirety because the court then take this view that there are only 2 permissible alternative spurs to go down. One is, was Mr Gormandy mistaken, having heard evidence that he was an unsophisticated farmer? Or 2, was Mr Gormandy deliberately inflating his claim to the land? And in choosing 2, both of those courts have effectively made a finding that Mr Gormandy was misleading or attempting to mislead the court by inflating the land holding in circumstances in which that was not the case that was put to him.
I mean, is that quite fair? Is it not rather that the judge thought for a range of reasons that he hadn't occupied the 4.6 acres? And while he may have been farming some other area, it was simply impossible to identify what area that would be.
Well, my lord, I think without wanting to quibble about semantics, but I do think the structure of Mr Justice Rahim's judgment shows what it was that he thought he was doing, because Mr Justice Rahim very much moves in 2 separate stages. He starts by listing all of the what I would call the good facts, and he then decides that once the chaff is dusted off, he can resolve the issue of acreages by reference to whatever one wishes to call it, but by reference to an internal judicial process of some kind, which is not exposed to any party for comment. And it's quite clear that by 403, Mr Justice Rahim has made his mind up. So at 403, Mr Justice Rahim then says the court therefore does not accept the evidence of Gormandy that he occupied the entire parcel of 4.6 acres. So at that point, the judicial guillotine has dropped on Mr Gormandy to the extent that his evidence that he occupied the entirety of the parcel of 4.6 acres is not accepted. He then moves on to phase 2. It is obvious that he occupied less. The evidence is that the land was not bounded by the river, nor by a housing scheme or a recreational ground, which on Gormandy's evidence was some 400 to 500 feet away. This tallies with an area used off Keskedy Avenue within the subject land for dumping of refuse. So the next stage he goes to is to say, well, that's supported also by the discrepancies between the verbal description of the parcels in the particulars of claim and in the 2017 sale agreement to Sammy, overlooking, however, first of all, as the Court of Appeal point out, that these boundaries were by reference to landmarks, and secondly, overlooking the fact that Mr Gormandy's precise boundaries were those which were set out on the cadastral plan. Unfortunately, in my particular line of work, it is not uncommon to find verbal descriptions of boundaries are wholly inadequate and don't lead to easy neighbourly relations. So it's not entirely surprising that the pleaded attempt to try and articulate those boundaries would itself not be a sufficient descriptor to allow the reasonable person with the pleading in hand or with the 2017 agreement in hand to designate the precise lay of the boundaries. That was the function of the cadastral plan. So that, in my respectful submission, wasn't something that should have weighed in the judicial mind. And then at 405, Mr Justice Rahim proceeds, having made the...
don't quite understand that. So you're saying that it shouldn't weigh in the judicial mind to take into account the differences between what's called the sketch plan and the cadastral plan?
Well,
to say that there is a possible explanation for the difference, which was advocated for before the trial judge and which was rejected, is one thing, but to say that it shouldn't be weighed in the judicial mind is another one.
Well, the verbal descriptors are not inconsistent with the cadastral plan. All the verbal descriptors are more or less accurate attempts to describe what the lines are on the cadastral plan. I think what your lordship is referring to is the location of G1 and G2 and the fact that the box moves from the bottom to the top.
Amongst others, because the actual shape of the sketch plan is different from the cadastral plan.
But as the Court of Appeal stated, I mean that is a sketch, that is an amateurish drawing, which again it can't be treated as anything more, in my respectful submission, than an indicative drawing.
But isn't that for the trial judge to decide, and for the Court of Appeal to decide? I mean, it is perfectly obvious that one potential outcome could be, well, he's an uneducated person, he got it wrong. Another outcome is, I don't believe him.
Yes, my lord, I hear that. But that is, again, to be weighed against the fact that Mr Gormandy gave his evidence about what he pointed out to Ms Mohammed, gave his evidence of how the cadastral plan came to be drawn up, and that was not the subject of a challenge. G2, I think, also was not the subject of a challenge put to Mr Gormandy. That was a challenge put, again, I think, to Ms Mohammed. So, my lord, I say that part of Mr Justice Rahim's reasoning at 404 is not even inconsistent with the cadastral plan. It is simply indicating that the drafter of the particulars of claim has deployed various verbal formulae to try and capture what it is that is shown on the cadastral plan being an annex to the particulars of claim, intended to show what the land claimed was. So Mr Justice Rahim gets to his 405, paragraph 405, having made that determination against Mr Gormandy on the basis of the intracranial process that took place without exposure to the parties. It's at this point that he marshals the evidence that he considers then supports that conclusion at 405. He has accepted, or he goes on to accept, the evidence of Ms Mohammed, that it was unshaken in evidence, that there was evidence of rotational agricultural use in the disputed land. He points out that Ms Mohammed does not go so far as to say that there is a photograph that shows all of the disputed land under cultivation at any one time, but rather in conformity with the practice of rotational farming, some parts were farmed and others were not at different times. And Ms Mohammed's account of that is by reference to aerial photographs in which she says that there is evidence of farming throughout G1 and throughout G2. Mr Justice Rahim also places reliance upon the ministerial letter of the 2nd of August 2013, and I've already addressed you on that. Yes, it is true, as my Lord Stevens pointed out, that this was an annexure to Mr Gormandy's evidence, but its significance only really became apparent when Mr Justice Rahim takes his turn in paragraph 401, 402, and finds that Mr Gormandy has filed an exaggerated claim. Again, there's no point at which Mr Gormandy was given an opportunity to explain why 2.5 acres was reflected in that letter, by what process that came to be measured, because the precise acreage was not an issue, at least until Mr Justice Rahim's judgment or the closing submissions. So that's why I say, my lords, that Mr Justice Rahim was wrong in step one not to expose to Mr Gormandy for comment the discrepancy issue, because the discrepancy issue differs from the were you in occupation or not issue. The discrepancy issue presupposes occupation and leads to Mr Gormandy losing because he is said to have exaggerated his claim and cannot then show what the lesser part of the land that he said he occupied was. And then that should have been exposed in my respectful submission for comment, particularly on the basis that both courts took the view that this showed a deliberate exaggeration of the claim.
Can you just point out to me, I'm sorry, you've already taken us to it, where the Court of Appeal said that Mr Justice Rahim...
It's paragraph 98.
Deliberately inflated. 98, thank you very much.
I'm sorry, I don't have... 1994.
Thank you very much.
And my Lord, where I say there's then a resultant difficulty is that although Mr Justice Rahim refers to then at 408 in summary of his judgment to the various factual material that he says is consistent with his earlier conclusion that Mr Gormandy obviously occupied less because he was bringing an inflated claim, that meant that Mr Justice Rahim did not deal with other evidence that he received that he had heard from Mr Gormandy and his witnesses, and that evidence was not the subject of any direct challenge. So that the first piece of evidence that Mr Justice Rahim heard was that at page 1294, in paragraph 29, that in 1985 he marked out the boundaries of the lands which he intended to cultivate. The lands were already bordered on the west by a chain link fence, on the south by Couva River. In 1985 he planted coconut trees and zaboka trees on our northern and eastern boundaries. I should emphasise these are not findings, but this is him recording the evidence Mr Gormandy gave him. He planted guava trees in the middle of the lands. The land he marked out was approximately 3 acres in size, the subject land. But the subject land is the land shown on the cadastral plan. It is not 3 acres. It is the subject land as defined, which is the 4.6 acres. It's his evidence that he planted those trees on the northern and eastern boundaries, and it was evidence which was corroborated by his common-law wife, Bianca Banswell, who indicated that there were trees on the boundaries, but also throughout the land in question.
I mean, does the fact that she said it was throughout the land rather reduce the weight of what you can get from her, or what the judge could get from her?
Well, Mr Gormandy himself accepts that he planted guava trees in the middle, and that other trees, fruit trees, were planted as part of his cultivations.
I mean, this is page 1003.
That's right, my Lord, yes.
So she's asked, was it opened on 3 sides? And she says yes.
Yes. But she then says marked by, obviously not fences, but she corroborates Mr Gormandy's evidence to the extent that he says he planted trees on the northern and eastern boundaries. And we also know from his evidence that he gave evidence to the court.
And when did he planted these trees in 1984?
When I've been slightly trying to understand what they mean by marked out or staked out.
Yes.
Because both those phrases are used, and at one point staked out is staked out with trees is the phrase.
Right.
So my understanding is that the trees were planted as a demarcation in 1985.
And the latest aerial photograph doesn't show them?
Well, I'd have to have another look at that, my lord, but that is the evidence that he gave in 1984-5. That is what he did to demarcate.
It was just my recollection, and I could be wrong, that the trees were never shown on any aerial photograph.
I think the court said that they couldn't see the trees. Yes.
Yeah. That may be because the aerial photographs aren't of sufficiently high standard, or that the trees aren't there.
One of the two, my lord, yes. But we do have the photogrammatic evidence of Ms. Mohammed, and we have some, I think the later photographs in the bundle are of a slightly better photocopy quality, if not inherent quality, that show the furrows that she refers to. But Mr Gormandy also gave evidence in relation to the marking out. And one passage I'd like to take your lordships to is at 881. And it's from line 19. The question was, you were able to clear the land. How did you clear the land, the 3 lots of land, when you were 17 years old, Mr Gormandy? I started with a brushing cutlass and a hoe, right? And every day I would work, and as I cleared, I planted and moved on. And everything you planted, you say, were given from other people who were farming, who got in the market, what I collected. So he refers to the marking out. And then if we move on to 884 to 885, he explains what it was that he marked out. He says at line 11, the question is at line 12. Now, according to you, by the following year, 1985, you'd staked out your 3 acres. Now, that question is asked in the context in which everyone knows the 4.6 acre plan exists, but the cross-examination proceeds on the basis of the 3 acres. Yes. You know what I find peculiar, Mr Gormandy? Look at you want to tell me as a 17-year-old boy you're staking out the area, and you would stake out the area with such a strange configuration. I don't understand what you mean there. This represents this big piece marked G1. Now, pausing there, in the context of being cross-examined about what he did when he staked out in 1985, and on the premise that it's 3 acres because nobody cared about the acreage or paid attention to it, he is being referred to the cadastral plan, which shows 4.6 acres. And he's being asked whether that is what he staked out. This represents what you sold to Sammy, yes, and G2, according to you, represents 2 lots that you kept. So you're a 17-year-old boy and you're staking out the land that you want to occupy, and you wouldn't have a straight line. You see, like how we have a straight line here on the north. Well, I guess that is what I did, yes. Not you guess. Yes, that's what I did. Did you or not? Yes. Yeah, yes. You sure about that, Mr Gormandy? Yeah. So the cross-examination about what he was doing in 1984, 1985, albeit referring to 3 acres, is by reference to the cadastral plan showing 4.6 acres, and Mr Gormandy confirms that is what he staked out, being asked about it. And we've heard earlier that he was taken to the cadastral plan. And he explained that he had rotated his crops over the subject land. That was his evidence. And that what started as a hobby became a business, and he sold his crops locally and then lately to a local restaurant. So that's the evidence that Mr Gormandy gave before the discrepancy point came to light in the course of cross-examination of Ms Mohammed and then thrown into sharp relief in the closing submissions. That evidence was also corroborated by what Ms Mohammed identified in her evidence, expert evidence, her photogrammatic analysis showing, in her words, there was planting throughout G1 and G2. I have to accept her evidence wasn't not the totality were under farming, but it was throughout. We also know that Mr Gormandy constructed a shack, that he employed people to work there, and if the need arose, he chased people off the land. So there was a lot of evidence before the tribunal that when Mr Gormandy was being asked about and was referring to the 3 acres, what he meant was what was shown on the cadastral plan, the 4.6 acres. And it's that he confirmed was what he had staked out in 1984-5, probably more 1985. So having received that evidence, that should have resulted in the court considering it and finding that Mr Gormandy in fact was consistent with occupation of the 4.6 acres. Instead, that undisputed factual material was ignored, and instead no findings were made on it, and Mr Justice Rahim instead focuses in paragraph 408 on those materials which he considers show that Mr Gormandy was not in fact in occupation of the whole, which I've already addressed your lordships on.
Can I just ask, what do you say? You say undisputed. What do you say was undisputed?
The passages that I've just taken you to do not put to Mr Gormandy that his staking out was not of the land shown on the cadastral title.
When it's put to him, well, you as a 17-year-old wouldn't have gone in for this shape, is that not challenging his evidence that that was what he'd staked out?
Well, it's not challenging the core fact that's so important in this case. It's challenging the shape of the eastern boundary. But what it isn't doing is challenging the acreage, which is ultimately what Mr Gormandy failed on. It is not saying that the cadastral plan that you have just referred to, which you said you staked out around, was not the land you were staking out. You were staking out something less. You were staking out 3 acres of that land. And the confusion is compounded because the label 3 acres is being used to describe the 4.6 acres. That's where this case becomes difficult to unravel.
But I mean, in 884 and 885, to which you referred, I mean, quite clearly the cross-examiner was calling into question whether or not Mr Gormandy had, in fact, staked out the area which he claimed later was the same area as the cadastral plan.
In which he well, first of all, he confirms that it is, but secondly, it doesn't put into issue the issue on which ultimately the case turned, which is the area.
No, but it is putting into issue the fact that it was staked out as he said it was. The area, I agree, became a critical issue in the light of the eventual findings of fact. But 884 and 885, surely, is the cross-examiner indicating that that a question is being raised about whether his evidence is correct. Hence, are you sure about that, Mr Gormandy? Yes.
Yes, my lord, but in my submission that doesn't quite go far enough, in the sense that if the submission is then going to be made, well, there is a discrepancy between 3 acres and what is shown on the cadastral plan, the 4.6 acres, the cadastral plan being the only document that shows the 4.6 acres. That is something that he should have been asked about if, as the court then did find, the finding is made that he has deliberately exaggerated what his claim relates to. And if the criticism is made of him, as was made in the closing submissions, that he had not given an adequate explanation of the discrepancy, and the reason why he hasn't given an adequate explanation of the discrepancy is because the significance of the discrepancy was not appreciated during the course of his factual cross-examination, and the evidence proceeded on the counterintuitive or unreal assumption that when everyone was talking about 3 acres, they were using that as a descriptor of the land shown on the cadastral plan. And so I say in relation to, as it were, the first issue, acreage and boundaries, that should not have been the first question that either the trial judge or the Court of Appeal ought to have asked itself and answered in the way it did. But it set the Court of Appeal and the trial judge down the road then of examining the evidence through the lens of the finding that he occupied less, which leads the court below to fasten only on the evidence in paragraph 408, which I say in relation to concurrent user, for the reasons I've explained, was not in law sufficient to deprive Mr Gormandy of possession, and in relation to the other material was either beside the point or not exposed to him for comment, as it should have been, and that therefore the court fell into error in the second regard by A, attaching weight to evidence that actually was immaterial or was being examined on the wrong legal basis, or B, disregarding the evidence which I've described as undisputed, which was received by the court from Mr Gormandy. A good example of that is that the Court of Appeal, but not the Mr Justice Rahim, attached significance to the evidence of Mr Andy Dubai when he said in his oral evidence that the user was fell around the area of Keskady Avenue, which the Court of Appeal attached importance to. The two things to say about that are that if the evidence of Mr Dubai in that regard is A, vague, but B, is contradicted by the aerial photographs which show cultivation throughout G1 and G2, G2 lying beyond Keskedy Avenue. So the Court of Appeal adds an additional hurdle to Mr Gormandy, but that is, again, not a finding made below, and it's also inconsistent with the aerial photography. So, my Lord, those are essentially what the issues are in relation to the judgment as far as the appellants are concerned in relation to the first and second issues. My Lord, I would also suggest that the court fell into error if it is accepted that the boundaries were clear because Mr Gormandy had identified them on the cadastral plan and they were never challenged in not applying the principle unum quid. So I would say that before we get to that, standing back and looking at the totality of the judgment, that none of the material that the court relied upon was sufficient to deprive Mr Gormandy of his possession of 4.6 acres. None of the material justified the court finding that Mr Gormandy was advancing an inflated claim. And the evidence that he did provide and that Ms Mohammed provided and that was corroborated by his factual witnesses ought to have been accepted as evidence that he was in adverse possession of all of the 4.6 acres, a position that is only strengthened if the court accepts that the boundaries in this case, on a proper analysis, were not in dispute, because that would then bring into play the principle of unum quid, which I've referred to in...
We can hear you, I think, later on that. Is there anything else you want to say on Debbie and Roy?
My Lord, if I could just check with my learned junior. I think my learned junior feels I've said enough.
Thank you very much. The board will adjourn to consider your submissions on Debbie and Roy and will return very shortly. It's 1:30. Yes, he has, yes. Okay. We'll return in about 5 minutes. Mr. Adler-Gardner, thank you for your submissions. The board is satisfied that you have said everything that you could say in support of your submission that the rule in Devi and Roy should not be applied. And the board is very grateful to you for those elegant submissions, but the board is not satisfied that Debbie and Roy should not be applied, and accordingly we need to hear you no further. Ms. Peake, thank you very much for attending remotely. We will not need to call on your services this afternoon because we are upholding the challenge based on Debbie and Roy.
Much obliged, my lord.
So, the board will produce a formal judgment in this matter and will take time to consider that judgment. We will now adjourn. Thank you.